All right, hello, welcome to the Life in Transitions Experts YouTube channel, Facebook group, podcast, and all the places where you can find really social media. My name is Courtney Rollins. I am the host of the Life in Transitions Experts channel. Let your light shine, LITE. I'm also the founder and operator of Estate Pro Service LLC, and where we help families make the probate and estate planning process easier, all while creating income and wealth primarily through real estate. And today I want to talk about um, clearing up some misconceptions about estate planning, particularly a document that a lot of us assume whether we need to have, and I would agree we need to have, but some may assume some things about it that aren't necessarily true. And that is talking about the last will and testament document. Now, I do have to give a disclaimer. I am not an attorney, nor am I giving legal or financial advice, just sharing my experience, and hopefully it's helpful to you. But please seek legal advice, particularly from that happy law, which is estate planning. Quite often they call it happy law because, even though we're talking about things like death and preparing for that, it still can be very people can feel a lot of security in making sure that their legacy is protected and established by having these things in place. So a will, last will and testament is not enough in North Carolina. Let's take a look at some of the reasons why. And this is going to be probably two parts. I'll show why a will is not enough, and then some legal documents in the next part, probably tomorrow, of what you can do to make sure you have that. So let's take a look at what probate is. Probate is the legal process for settling the affairs of someone who's passed away. If you die with property in your name, or if you die with debt in your name, and you don't have legal instruments in place or documents in place, your family will have to go through probate, and it's long quite often. It's public, and it can be pretty expensive with all the filing fees and the regulations that are set forth there. So it's something you really want to avoid. It's like putting your family through a civil lawsuit, and it's not necessary when you have tools in place to avoid it. So a lot of folks think that a last will and testament, which that's exactly what it is the will and testament of someone, their last statement that they want to make about where they want their property to go, how they want things divided, and their wishes for their burial, things of that nature, are all set up in the last will and testament. And it is a I would almost say legal suggestion to the state that is directed to. So it doesn't necessarily have to always be followed is one of the limitations of that, but it is the legal suggestion. And in fact, the probate process is what probates the will. When there is a will, it has to go through probate so that it can be carried out, executed. That's why they call it your executor. You're executing the wishes, the last will and testament. And the will serves as the legal guide or the suggested guide. Again, it doesn't always have to be followed, but in most cases, we try. Some of the limitations is that it has to go through, like we said, it has to be validated by a probate court in most states. So that's one thing right there. So you have the last will and testament, you completed it, awesome, but it still has to go through probate. So there are things we'll talk about the next podcast on what you can do to avoid it. But it is still good to have because at least you have a guide telling the state how you want things carried out. Again, it is public record, so folks really like me and other folks who are looking for people who may need support can follow you. So whether that's a good thing or a bad thing, it really depends on your situation. And some people like the to have their stuff private, so know that your will has to be public, so that that's the testament. That's by law. Other thing that it can go through disputes and challenges, whether it's disputing whether it's valid or disputing whether it's needs to be followed. There can be disputes and challenges that still can be addressed even if you have a will and testament. There's also it has limited control over like non-probate assets. There are some assets that don't go through probate, whether if you have like a bank account that has designation of beneficiaries, or there's a trust that owns certain properties, or there's a property like real property like a house or land that doesn't necessarily have to go through probate in North Carolina. It has limited control over there. So understanding that uh, helps you understand the limitations that a will has by itself. A will is important, but it's limited. So those are some of the things that reasons why a will is not the end all be all. And tomorrow I'm going to go over in the next part, go over some of the ways that legal instruments and tools you can use coupled with the will to make sure you have a comprehensive estate plan. Feel free to reach out to me if you want to take advantage of the network of estate professionals that I do know in North Carolina and in the nation. Courtney at estateproservice.com, or go to estateproservice.com and check out some of the resources we have there. Love helping folks out. It's the way I get to give and get to be, compensated for it. I found a lot of property that way. Even if you don't have property, I would love to help. Or if you have property, you want ways to keep it. You don't have to necessarily sell it to me. I don't force my agenda onto you. I try to really just fit into your journey and be a part of that journey. All right. So I would love to hit the like and subscribe so we can meet and reach more people as well. That is the Life in Transitions Experts YouTube channel. That's LITE. Let your light shine. Cheers.